next matter now. So permit me to just see and the thing to just bring process up to date. The amount of questions that I've had to answer in terms of what transpired in court yesterday, I will try to explain as best as I can. Because as far as I've been told and I'm aware, it's an unprecedented matter. And basically what happened is that the state, through the prosecutor and SOCU, they have sued the magistrate that is presiding in this conspiracy to commit fraud charge that was leveled against myself, several retired and former police and serving police officers. The state sued the state. Well, let me walk you through, as I've said best I can, the whole thing. And again, to let you know that certain issues in relation to the evidence and all that, I cannot go into this matter, is before the court. And as I say, it's sub judice. I can't and we can't discuss certain details with you. So please don't ask me about those things. I tell you what I believe is okay for me to reveal. Now, you may recall that in May, actually on May the 19th, 2021, Mr. Conway and other retired police officers were arrested and a charge was filed on the 19th of May, 2021, alleging that we conspired to defraud the Guyana Police Force of $10 million and something by pretending or by purporting to revise a standing order which had already been revised. That is the essence of the charge, filed on the 19th of May, 2021. Some persons, I was overseas at the time, some persons who were present in Guyana appeared in court the following day, the 20th of May, and those persons included Mr. Conway, and were placed on bail. Now, the charge was an indictable charge. And let me explain to you what that means. Today's is teaching again. Take out your notebooks, make note. The charge was an indictable charge. An indictable charges mean that when you appear before the magistrate for that first time, you're not required to plea. The charge will be read to you, and the magistrate will tell you that the charge is indictable. You are not required to plea. Right? So you're not required to plea, and then you're put on bail. Now, if the charge continued to be an indictable charge, then what you're going to have a preliminary inquiry. The magistrate conducts a preliminary inquiry to determine if a prima facie case has been made out against you. Because an indictable charge really is tried by a judge and jury. Now, if the magistrate decides that an indictable charge is made out against you, then you're committed to stand trial and you're subsequently indicted. Now, there is this thing that they call the Administration of Justice Act. We call police abbreviated AJA of 1978. Now, the AJA, the Administration of Justice Act, provides for indictable charges to be tried summarily. Hear that? The Administration of Justice Act, 1978, provides for indictable charges. In other words, the charge is laid indictable, an application is made by the prosecution for summary disposal, and the magistrate has the discretion to decide, yeah, she's gonna or he gonna dispose it summarily, or no, we're gonna continue to do a preliminary inquiry and let the judge and jury decide. You will recall that in many of the recent cases, these politically motivated cases, the defense counsels have argued for the matter to continue indictably because they're saying it is best for the matter to be tried by a judge and jury. In other words, the defendant or the accused in that case wants to be tried by the judge so they can get a jury of their peers to determine their guilt or innocence. That is what that is. Now, once it is decided that an indictable matter will be tried summarily, as in this case where we are charged for conspiracy to commit fraud, then the magistrate rules, and let me say this before I go that prior to 1978 and the enactment of the Administration of Justice Act, the defendant or the accused person had the say as to whether they wanted the matter to be tried by the magistrate or whether they want a judge and jury trial. The defendant had a big say in that. But the Administration of Justice Act of 1978 removed that from the defendant, and it is left to the magistrate to make that decision. Now, once the magistrate decides that you're going to have a summary trial, then the law says that the prosecution is then compelled to do what we call disclosure, full disclosure. In other words, all of the evidence that they intend to use in the trial, statements, documents, exhibits, and all of these things. Well, not necessarily exhibits, because you're not getting prosecution, but you have to let them know what are the statements, what are the other things that you intend to use, so that they can have an opportunity to properly prepare their defense. That is a standard arrangement. That is a legal arrangement. So at some stage after these charges were filed, the court held that they're going to have a summary disposal. That was in Code 3. Now, once they make that decision as a summary disposal, that is the time when you are required to plea. Remember I said earlier, when an indictable charge is read to you as a defendant or an accused, really, once it's indicted as an accused person, you are not required to plea. You would have seen in the news many times the report to say the charge, a man charged a murder, charge was read to him, and the magistrate said he was not required to plea. That is because it is an indictable charge. You're not required to plea. But when you have an indictable charge taken summarily, at the time when that decision is made, most times, then you enter a plea. Once you enter the plea, the prosecution has a legal obligation to present you with all the evidence, all the statements, all the other evidence that they're using in you, what we call disclosure. They have to make a full